Okay. Mr. Singhvi, then here's a logical question. Pre-2017 election funding in this country was rotten, which is why the BJP says we had to look at electoral reforms. Electoral bonds were one of the way. Now the Supreme Court is telling us that even the electoral bonds are rotten. So pre-2017 is rotten, post-2023 is rotten as well. What do you do? My point is, would India have been served better and its elections served better if the Supreme Court had let the electoral bonds stay but removed the clause of anonymous donations to say whoever wants to donate can come and donate, but it will not be anonymous?
Exactly similar argument was raised during the course of arguments. That if you do away with this, you'll get a worse situation. Don't do away with it because you get a worse situation. The answers are very interesting. One, if there is a pre-existing situation which is superseded by an unconstitutional scheme, no doubt a scheme is held unconstitutional only retrospectively as it has now been done in 2023. But if a pre-existing state of affairs is revived by the setting aside of an unconstitutional scheme, that is no answer that scheme should not have been held unconstitutional. That scheme has to go. What was there before, we'll see. Number two, the court said we're not inhibiting you to create any other scheme.
No.
Create 20 other schemes. When they come before us, we'll again test them. But yours is not the last word that whatever scheme I create must be kosher and held by your lordships to be kosher. Because if you remove it, there'll be, after me, the deluge, as the French nobility said. There is no such thing. Let the government come with a proper scheme. The scheme could be a scheme where everything is disclosed and people, donate. The scheme could be some other variant. We don't know. You can't start opining in anticipation on a non-existent scheme. But you cannot uphold this scheme on the ground that without this, there'll be chaos on the old scheme. That is completely a wrong argument. It has been debunked by the court time and again.
Do you see, and I'm asking you this question because this is a question that is floating in the air, do you see the government going ahead and bringing in an ordinance to counter the Supreme Court's surgical strike? After all, these elections are barely 2 months away and everyone could do with some money.
I have no doubt that this government can try anything and they may try that. But they would be really foolhardy to do it. I think it will be ridiculous. They'll paint themselves with mud for the simple reason that the two principal grounds on which the scheme has been struck down in the last era is very clear, is on 19(1)(a) and on 14. Something unconstitutional under 19(1)(a) and 14 cannot be revalidated by a statute or ordinance. A statute or an ordinance is well below 14 and 19. So you have to pass an ordinance or statute under your theory, which says whatever was there in the bond scheme, we are now reproducing it in an ordinance, which is a statute, right? But whatever was in the scheme has already been held to be violated of 19(a) and 14. Then how can the statute, which repeats the same thing, survive?
Mr. Singhvi, my last question to you. How do you, given the fact that this verdict has come...
Mr. Singhvi, my last question to you. The fact is that the verdict has come 2 months before the elections. Do you see it in any way shaping these upcoming elections? Because look, fact is the verdict was reserved by the Supreme Court on November 2nd. So I'm fairly certain that all political parties, especially the BJP, had seen this coming, and therefore the money required for the polls is already with political parties. So do you see this verdict shaping the upcoming election in any way?
I entirely agree with you, and I started my comment in many programs that I did say briefly in your show that this judgment is very adequate. I welcome it. It's very comprehensive. It's very good. And it's something which had to happen, should have happened. But I fault the Supreme Court as an institution, not this bench, that in 2019, when you passed an interim order, it was incumbent and obligatory on that bench to take up the matter in the near future and decide it. Not doing so has meant that you have allowed the fruits of the poison tree to be enjoyed by its creators almost, I use the word almost, between two electoral cycles. The most important being 2019 itself, the national elections. Now, we can't rewind the clock. I think that it's an institutional failure on the Supreme Court's part not to take it up then and decide. This bench has done a wonderful job in fast-tracking it and hearing it, but that bench can be faulted. However, it will have some marginal impact, because certainly what monies have come in will be known, can't be taken away, etc. But future things have stopped. There are still a few months left to elections, A. B, there is a far greater degree of care, transparency and accountability now. So to that limited extent, I agree with you that 2 months is not much. So largely the fruits of the poison tree have been enjoyed.
Okay.
But then that's the way the law of system functions. You can't do anything about retrospectivity or rewinding the events.
Okay, Mr. Singhvi, we'll leave it there for the moment. Thank you very much for your perspective on the big verdict that has come out from the Supreme Court. The Supreme Court hitting where it hurts, actually, saying that all the bonds that have not been encashed, the money has to go back to the donor. So that's a double whammy for political parties. Thank you very much, Mr. Singhvi, for joining us, and good night. And thank you to our viewers for watching, and good night to them as well.